Good, good evening. This is John Milburn for LAWS11057, Introduction to Law. This is week 3 of term 3, 2018. Thank you very much for joining. We have a lot of people online, and that's always very encouraging. As usual, I encourage you to ask questions. Please unmute your microphone to do so, or ask using the chat facility. I'll attempt to monitor that as we proceed. And by all means, if you have questions as we progress, use the Q&A section on Moodle, and I will attempt to resolve any issues outstanding. Firstly, did we enjoy watching movies over the last week or two? Did anyone find a movie that they hadn't realised was so good and inspires you in law? Any quick comments? Yes? Tuna, what did you find?
12 Angry Men.
12 Angry Men, excellent.
Was brilliant.
It's an excellent movie, and it's very good for other subjects, other units. I use it in ADR and evidence in proof, so useful one. The Devil's Advocate, oh, that's scary. That's Al Pacino, isn't it? Back to School was Rodney Dangerfield. I hadn't thought of that as a law movie, says Tim. Any other recommendations? All good? All right. Let's move on to some of the substance for this evening. Now, as indicated previously, I do expect you to complete all the reading for the week and the week ahead, and always please skim through the material so that you've got a good idea of where we're going. Tonight, I want to start by talking about the levels of government, and there are different ways of looking at government in Australia. So firstly, in one way, we can say that we have the federal parliament. Below that, we have the state and territory parliaments. And below that, we have the local councils. So if you like, that's 3 levels of decision-making relevant to Australia. However, you will find that the terminology sometimes becomes confusing. And despite sometimes mixing terminology, the Australian Parliament, or the Federal Parliament, is not the same as the Australian Government. So we find that governments do change, of course, but Parliament remains as, if you like, a fairly constant. The Australian Parliament, in fact, consists of the Queen, represented by the Governor-General, the Senate, and the House of Representatives in a national sphere. So Parliament makes laws, provides a place where government is formed, and the Australian government is formed by the party or coalition of parties with support of the majority of members in the House of Representatives. I expect that you'd find that all pretty basic, but does anyone want to ask any questions about the difference between Parliament and government at a national level in the sense that I've just used it? All right, let's move on. Now, I want you to look at figure 4.2 on page 122 of your text. And what you'll see in that is a flow chart, if you like, noting something about the separation of powers. And I appreciate that I'm asking you to read ahead, but this is all consistent with what I want you to do in terms of flicking through the material and finding relevant parts. So I mentioned government earlier as being different from Parliament. But in fact, another way of looking at government in total is to say that government is partly constituted by the legislature, partly by the executive, and then partly by the judiciary. And when you see that those 3 levels written in that manner, what we're really doing is referring to the separation of powers. It's a fundamental consideration, and legislature makes the laws, the executive administers the laws, sometimes enforces the laws, and the judiciary interprets the laws. In Australia, the separation of powers is not strict. It's based on the Westminster system in England, and I say it's not strict because whilst the judiciary remains somewhat separate, or in fact quite separate, from the other 2 branches of government, there is some crossover between the legislature and the executive. So, for example, the Prime Minister and ministers are part of Parliament making laws, but they leave Parliament and then the ministers will go to their government office and head up the government department, which is the executive. So the same person on the same day may be part of legislature in the morning and then be part of the executive, as it were, in the afternoon. I hope that makes some sense. In the United States, there is a strict separation of powers between the legislature, which is the Congress, the executive, the president and the secretaries of state, and the judiciary, the Supreme Court, etc. So you will find that when we talk about government, we're talking about those three arms, and we'll refer quite often to the separation of powers. So please keep that as a handy guide. Now, can I ask a quick poll, just yes or no, just to get you started? Has anyone looked at the Parliament Education Office website, the Parliamentary Education Office website, for information about the way in which Parliament, judiciary, executive work, and other information about the making of laws? So yes or no, have you visited the PEO website? And I thank you for your honesty. We're getting mostly no's, a couple of yeses, and that's not surprising. Yes, constitutional law with Joe Bird. Now, the reason I'm suggesting that you should consider this is it's an excellent website. It will supplement, not replace, but supplement what you have in your textbook, and it has some excellent flow charts, some ways of working around the legislation diagrammatically that will assist you, I'm sure. You need to prepare a toolkit, don't you, for your second assessment. Have we all looked ahead? And we know the second assessment is the toolkit. The website is the Commonwealth Parliamentary Education Office, PEO. So in your website, or in your toolkit, you'll need to provide some commentary in relation to the resources that you use when practicing or studying law. Matthew's come up with it, www.peo.gov.au. Thank you very much. So this sort of information will help you in terms of providing some structure to the way in which you conceptualise lawmaking and decision making. Now, when we talk about laws being made, we do so in two broad manners. So can you tell me broadly, in Australia, who is responsible for lawmaking? And I'm using lawmaking in a broad sense. Two. I want two, not Commonwealth and state, but I'm thinking in a different way. The Parliament, the Senate, not quite. There's an answer I'm after. Parliament, judiciary, judges, which is judiciary and Parliament. The Queen, Governor-General, not so much. The government and judges, yes, but not so much the government, more Parliament. If we take away that, if we think of government as being the three arms of government, being the legislature, the executive and the judiciary, what I'm really suggesting is that lawmaking is in fact determined by Parliament, which is legislature, and the judiciary, the courts. And we don't often think about the courts as having an ability to make laws, but the courts do. Now, does anyone want me to explain further why I've made this distinction between legislature and judiciary? Well, I will. So legislature is easy because when we look at a statute, we determine that that came about as a result of going through a process. It was a bill, it was introduced, it was argued in the Parliament, in the bicameral systems. It went through the lower house, then the upper house, and eventually became an act. In Queensland, we have a unicameral system, meaning that we have no upper house. Once it goes through the House of Reps, it's then assented and becomes an act of Parliament. So parliaments make essentially statutes. Another name for statute is Act, capitalised ACT. So that's not a capital A, capital C, capital T. No, it's capital A and then CT, as in Act. So that's Parliament making laws, which are statutes or, if you like, called acts. But the common law is that which is created as a result of decisions made by judges. So do you remember, I think a week or two ago, I used a maybe very basic example. In the household, something is written down. These are now the rules of the house. 1, 2, 3, 4 goes on the fridge. If you like, that's Parliament creating laws. But when there's a dispute, when there's some interpretation required, well, what does Law 3 mean when it says everyone must have put away their toys by tea time? If I've put my toys away, by 5 p.m., is that tea time, or is tea time something else? Do you know what I mean? So it's a question of then interpreting what the Act says. That's where the judiciary comes in, makes a decision, and then that decision may become binding on other courts in other similar scenarios. And as a result of the courts creating these precedents, we build up what's called the common law. So common law is essentially judge-made law. And most of the law 100 years ago was in fact common law. And when Australia, when the English came to Australia, it was pretty much all common law. A few statutes, but not much. Overwhelmingly now, and increasingly year by year, the law in Australia is dominated by statute. The common law is progressively becoming less important in a way, but it's still there. And often, in fact, once the common law comes into existence, it, if you like, for want of a better term, to cite Justice Murphy, it circles the statute. It's not creating something which is standalone. So in contract law, when you study contracts, you'll find that originally most of it was common law based, where there were no statutes, judges kept making decisions, and rules were created as a result of those decisions, which became the common law. Now, say in land law, we have very specific detailed statutes, and those cases that are made as a result of interpreting those statutes become part of the common law, but they surround the common law, they supplement the common law, they supplement the statutes, they don't overtake the statutes. Does that make any sense? Are we okay? All right, so some questions here about the unicameral system versus the bicameral system. Personal preference really, I guess, but in Queensland we have that unicameral system. All right, any questions? All good? We have a lot to cover, so I'll move on. Legislation overrides case law is a general rule. Federal Parliament laws override state Parliament laws as a general rule. Have a look at the case of Ridgway against the Queen. It's 1994, 185 CLR 19. I do hope that's the correct citation. Ridgway was interesting. Here's the facts of Ridgway. Ridgway was participating in a controlled importation of heroin, was arrested because of a tip-off by an informer. Authorities allowed the informer to pass through customs uninhibited and delivered the heroin to Ridgway, who was then arrested. Now, the High Court quashed Ridgway's conviction, ordered a permanent stay of proceedings, and recognised the judicial discretion in criminal proceedings to exclude evidence on public policy grounds where the commission of the offence was procured by unlawful conduct on behalf of enforcement officers. In other words, in that case, the case is Ridgway against the Queen. When we say against, we mean v. So what was this case all about? The informant was passing through customs with their knowledge against the law to pass it on to Ridgway. And the court in that instance said, we are going to not allow that unlawful conduct on behalf of law enforcement officers to lead to a conviction. So it's an example of how the law can be created as a result of a circumstance. However, where it becomes more interesting after the case is this, that Parliament didn't like the outcome from the courts. And as a result, the solution, in a way, was quite easy. Parliament simply needs to legislate to override the decision of the courts, so that now the law becomes that which is in the statute rather than that which was decided by the court as a result of the precedent. So Parliament inserted Section 15X in the Crimes Act, Commonwealth, to permit law enforcement officers to engage in what they call controlled operations to obtain evidence against a person who's involved in a serious state matter. Now, it wasn't retrospective, so they didn't get Ridgway, but it does create a situation that someone in the future cannot argue the Ridgway principle specifically to that case, given Section 15X has now been introduced by Parliament. And it's an example of what I described, I think, at an early stage of something which is cyclical. And Tuna has corrected me. You are right, Tuna. It is 1995, not 1994. So Ridgway against the Queen. As an exercise, do try and find that. Now, common law and equity. Has anyone come across this term equity yet? Have a look at page 99 of your text. And I know I'm bouncing around the text, but it's quite intentional. You need to look at all of this and take in a lot of material all at once. Page 99 deals with the issue of common law and equity. I need to go into a bit of history here, English history. English citizens had an opportunity to have matters heard, but when the case was decided by the courts, they would, generally speaking, some time ago, adopt a very hardline practice, what we call black letter law. In other words, it didn't really result necessarily in something that was fair, but it resulted in something that was certain. Everything was taken very literally, and that's why we call it black letter law, as if what the words are on the paper mean everything. Now, those people that were dissatisfied with that could go to an alternate jurisdiction, which was established by the Lord Chancellor, and the Lord Chancellor had, it was him, but his own court-making decisions, and they did so based on what was fair. Don't worry too much about exactly what's written on the page, what's fair in these circumstances, and we call that, those decisions became the decisions in Chancery or equity. So they were equitable decisions. And obviously there was a discrepancy between the way in which the two systems, for want of a better term, worked, and equity was based on fairness. And in the coming up with a number of cases over many years, principles started to develop so that people would have to come into a court of equity with, for example, clean hands. What does that mean, clean hands? Does it mean literally clean hands? Any thoughts? So what we're saying is, and this is still a principle of equity, no convictions, not quite. Good character, not quite. Along the lines, they can't be wrong before coming to they can't have done wrong before coming to the table, says Tanya. That's the answer I'm after. Yes. So if you were to go to the court of the Lord Chancellor, equity, the court would say you can come here and you can seek justice, but you cannot have done wrong yourself leading up to the dispute or involved in the dispute because we won't assist you. So it was just an equitable principle. And they kind of became little catch cries, if you like. Another one is equity looks at intent rather than form. And that kind of goes to equitable principles. So common law, the judge-made law in black letter law was very rigid. It was very inflexible. And it didn't look so much at the intention behind it, but equity did look at the intention behind the agreement, and it looked to the spirit. Equity looked to the spirit of what was agreed rather than the black letter of what was written on the page. So that was equity looks to the intent rather than the form. So in the case of sale of land, if a party fails to complete within a fixed time, in a contract at common law, the breach of contract was very quick and severe, but equity took a less rigid approach and allowed people a reasonable time to complete their obligations. They're just general terms. Now, here's where I'm going to confuse you, but try and work through this. Very often in law, you'll find that the same word or the same term can have different meanings. And sometimes it's a global meaning, sometimes it's a more specific meaning. So when we talk about the common law as opposed to statute law, we're really talking about that body of decisions made by judges generally that has some useful precedent value down the track. So that's common law, contrasting it to statute law, that which was made by Parliament. But another way in which the term common law is used is to distinguish it from equity. So sometimes you'll hear of this distinction between common law and equity. Common law, in that sense, if you like, as subset of the larger common law, means those decisions that were made relatively rigidly and inflexibly, as opposed to the common law, or as opposed to equity, which was more rigid, which was less rigid and more forgiving. So where you will see this occasionally throughout your studies is mostly to do with remedies. And I'll give you some examples, and stay with me on this. Hopefully you can follow. So if, for example, you decide to buy a block of land, you sign a contract, the seller, for no good reason, says, I'm not selling it to you. You can have damages. But you could buy another block, but it's not the one that you had planned. It wasn't the exact block that you wanted. So damages is a common law remedy, typically, but you're not really happy about that remedy. You actually want that land. So in equity, you could go to a court of equity and say, what I'd like is an order forcing this person to sell the land to me because it's kind of unique. And if the court of equity said, yeah, we agree, we're going to force them to do it, that would be ordering what's called specific performance. Specific performance is an example of an equitable remedy as opposed to a common law remedy, which is simply, don't worry about that. They've breached the contract, but we'll give you money by way of damages instead. Can you see the difference? That the difference between common law and equity sometimes manifests itself in terms of the different remedies available to an aggrieved party. Does that make sense? Here's another one. Let's say you want to stop someone from doing something because it's going to affect your livelihood or your family, or there's some good reason to have someone stop something. We call that, what's the remedy that we seek if we're asking for the court to make an order to stop someone from doing something? We've got one correct answer, two, a few different answers. Primarily, yes, I agree with the majority there, injunction. We've got a few others, cease and stop order, they're fine too, but the usual term, the equitable term, is injunction. And that's another example of an equitable remedy that is not available, if you like, at common law. So you can see that at common law means something different there when we're contrasting it to equity as opposed to what it means when we distinguish it from legislation. Don't worry, you'll kind of get used to it. You'll just float into this and it'll become more sense. It'll greater sense. So damages is not only a common law remedy, it's also an equitable remedy, but we think about damages in the context of common law typically. Another, Tim says, what about unjust enrichment? Yes, so that's another example. Benjamin asks a really good question. So do you need to go to an equity court, or is it what you just ask for in the courtroom? That's a really good question and not an easy answer. My personal view is that we need to look at this from a global perspective, and I think make it simple, make it simplified. I'll answer your question with a longer answer, and I don't like doing that, but I'll try to make it as quick as possible. In short, not every court nor every tribunal has power to make every order that you want. Some courts are invested with full common law and full equitable jurisdiction, unlimited. So, for example, the Supreme Court. The District Court also has equitable jurisdiction, but the Magistrates Court generally does not. I have to say generally because magistrates do have a power to make some sort of declarations, which is an equitable remedy, but generally speaking, Magistrates Court do not have equitable jurisdiction. Some tribunals, in some parts of the tribunal, do have equitable jurisdiction. So, for example, in QCAT, we do have power to grant injunctions or make declarations. So it just varies, and it can be court by court, and you have to kind of get used to that. But when you're looking to construct your toolkit, be very mindful of which courts seem to have certain powers, so that if as a result of using your toolkit, you need to follow a process to determine for a client which is the appropriate jurisdiction and what is the appropriate remedy that you seek, it's not just a matter of going to any court or any tribunal and expecting that they have full power to make the wide range of remedies that might otherwise be available. So when it comes to the jurisdiction of a court or a tribunal, sure, you have to think about sometimes the monetary levels, but you also have to think about the available remedies to the court in those circumstances. Don't worry about it just too much now, but just be aware of the distinction. So in Queensland, we don't have an equity court as such, but the appropriate terminology is to say that we have some courts that are invested with an equitable jurisdiction, as opposed to other courts that are not invested with an equitable jurisdiction. Oh, it gets complex, I'm sorry. But that's why we get paid the big bucks to work through these issues. So it's all, you know, there is a bright side to it. Now, and you'd think it would be the other way around. Yeah, that makes sense. Okay, so at this stage, let it go over the top of your head a bit, but just be aware of this distinction and make sure that you start to build it into your toolkit. So you'd probably want to have some heading jurisdiction of courts and tribunals and start to work through it. We'll talk more about that shortly. In the spirit of bouncing around so that you get a global picture here about Introduction to Law, let's have a look at Chapter 4 of your text, The New Lawyer. It commences at page 115. It goes all the way through to page 151. It's the Australian legal system. There are 7 characteristics. Please read that. The rule of law, liberal democracy, common law legal system, constitutional monarchy, federation, separation of powers, we've dealt with that tonight, and responsible government. So these characteristics are detailed in your textbook. Read them, understand them, and get an idea of how they work to contribute towards our overall Australian legal system. Let's have an example. Go to page 145. And what we have here is some commentary in relation to challenging the executive, or more particularly, challenging executive decisions. In order to make sense of that part, firstly, we need to clearly understand who is the executive. What does the executive do? And only then can we decide how to go about challenging the decisions. So based on what we've discussed tonight, can anyone give me an example of something that forms part of the executive? Could be state, could be federal. Who or what is an example of the executive? All right, so we're getting some answers coming through. Commonwealth, Cabinet, Ministers, PM, couple for PM, Government Department. I like that one. Ministers, Departments, Executive Council, Planning, Premier. So a wide range of options there. When I think of the executive, I think, well, the minister is in charge of part of the executive. What part of the executive? I think about departments. So executive, to me, the first thing that comes to mind is government departments. And each of the government departments are headed by a minister, yes? So hence a ministerial request, even though that minister is part of Parliament, as we discussed earlier today. So let's assume then, and public service, says Ronnie. So yes, we'll think about government departments as being the executive. Tuna said Premier, yes, kind of at the top. Someone said planning. Now, who was that? Where is it? Timothy said planning. It's a good example of an executive decision, isn't it? Timothy Faint says, is that like Defence, Foreign Affairs Department? Yes. Office of Foreign Trade, Fair Trade, etc. So yes, these are executive departments. And what the executive does is it makes things work. So the executive doesn't make the laws, or at least we'll get to that. Parliament makes the statutes. The courts interpret the disputes and interprets the laws and therefore makes the common law. The executive strictly doesn't make law. It makes things happen, doesn't it? So the department will make things happen, but it will also make decisions. So here's where the executive's interesting. And that's why typically we talk about the executive in the middle of the three arms of government. Because the executive can make some law, does have some law-making ability if Parliament gives it to the executive. I'll just explain that for a sec. Parliament makes statutes, but it doesn't make every piece of what you might think is a statute because it's too busy. It will delegate some powers to the executive and say, all right, in relation to this area of practice, we're not going to micromanage. We are going to give to you, the executive, to the department, the power to make some laws. Can anyone give me an example of something, a name, a general name for a law made by the executive as a result of power given to it by Parliament? Bylaw, we're on the right track. Regulations, yes. Any others? Ordinances, things of that nature. By far the most common, and Megan, you're right, is regulations. So when you see a regulation, it does have legal effect. It's binding, isn't it, on citizens? You have to comply with regulations, but they're not made by Parliament. They're made by the executive under what is termed delegated legislative ability. So regulations are an example of delegated legislation. So Parliament says, we're too busy, we don't want to make all these things. We'll give you the general power. You can make your regulations, your bylaws, your ordinances. It's still binding on the citizens. You don't have any power under the Constitution to do that. Your only power comes from us, says Parliament. And then what gets interesting with the executive is this. The executive then has this obligation to make things happen. So the government department issues licenses, permits, it makes decisions, and it can actually then prosecute, can't it? So it has this prosecutorial function as well as the general executive function to make things happen. All right, it can almost become like a judge and jury in the sense that it can issue infringement notices. So it seems like the government department investigates, the government departments determine whether you're right or wrong, the government department then imposes the penalty. So it's almost like it doesn't worry about the separation of powers in that sense. I hope I'm not confusing you. Are you staying with me? Parking tickets? Yeah. All good? All right. So that's what we mean by executive and executive decisions. Now, what if the executive makes a decision, imposes an infringement notice, changes a town plan, or does something that you really don't like? What can you do about it? Or, in the context of being an advisor, what can you advise your client to do to seek some redress? Okay, we're getting some answers coming in. Ombudsman, yes. 2 responses there. See the Ombudsman, go to courts, AAT, call the Minister. So some different opinions there. Absolutely. Depends on what the issue is. Yes. So let's break that down. Some very good responses there. You can challenge an administrative or executive decision by going to the Ombudsman, and you're then asking someone to independently investigate and provide possibly a recommendation. Another is to say you can go to the courts. What sort of things do you think you could ask a court to consider in general terms about an executive decision? And I've got 2 things in mind here. This is very obscure. Constitutional law, that's a good point. Yep, potentially. Is it constitutional? What are the circumstances surrounding the event, says Sandra? What if, let's take a silly example, ask for an appeal. Yeah, let's take a silly example. I'm doing this off the top of my head, so we'll see if this works. A representative of, say, the Department of Health issues a notice to say that their neighbour's dog is now a menacing dog under the Dogs and Cats Management Act. You receive this and it's signed by a representative of the health department. Now, are you bound by that notice? Is your dog, in fact, a menacing dog? Because you received the notice and it's signed by someone from the executive. We're getting some answers in. No, no. Why not? Evidence required, yes. Peter's got it. Peter's got the answer I was looking for. And Timothy came in a fraction of a second afterwards. Do they have the authority to make that decision? Is it outside the scope of their authority? Is it outside the scope of their power? So the executive representatives are conferred with certain power, and they can't go beyond that power. Matt says, not the right department. Exactly. So if you're advising someone about an executive decision, it seems to me the first thing you should do is check to ensure that that person purporting to make the decision, in fact, has power to do so. The Latin term for challenging a power decision made beyond their power is called, does anyone know the Latin term? It's 2 words. I'm just giving you a chance to show off here. Not quite OB. Ultra vires. But don't worry, we don't use much Latin anymore, but you might hear that term. So if someone makes a decision beyond their power, you can attack it on that basis. It is beyond their power, it's ultra vires. and Peter says that the whole government's extremely departmentalised, becomes evident when you do some lobbying. Absolutely. So what we've identified, firstly, is you can go to the Ombudsman, we can go to the courts, but if you're going to the courts and you're asking for some redress, it may be that you're asking the court to make a declaration, and this is an equitable remedy, that the decision made by the department was beyond its powers. So we call that a review of the executive decision by the judiciary, and therefore a judicial review. A judicial review is different to another type of review, which is what we call a merits review. So, for example, if a government department actually does have the power, for example, to declare a dog as a menacing dog, and you're not happy with that decision, then you can then go to the appropriate, in this case, tribunal, QCAT in Queensland, and ask for QCAT to review that decision of the executive, and that's what's called a merits review. The tribunal's not looking to see if the government had power to make the decision. It's looking at the decision itself and asking the question, what is the correct and preferable decision in these circumstances? Yes, Maddie, have you got a question?
Wouldn't it be a local council though? I've had this issue with my dog. He bit a postie. And I had to deal with the local council. And yes, it's a government, but I never had to go to the courts or QCAT. I had to deal with them.
Yes. So the ability, the delegation of power to make laws, to regulations, to enforce can filter through the state down to the local councils. And you're right, that's a local council issue. But the challenge is to the tribunal as a merits review. I hope that makes sense. You can still ask for a judicial review, but if you go to the courts and ask for a judicial review, what you're really saying is the decision was biased, it went beyond its power, etc. So some legal basis as opposed to making a decision on the merits. In your textbook, you'll see reference to the Administrative Appeals Tribunal, and that makes an administrative decision rather than judicial decision, and it makes its decisions as a merits review. The counterpart in Queensland, it's in the text, is the QCAT. So that's the difference, if you like, between merits reviews and judicial reviews. And I raise that as an example of the difference between the executive and the judiciary and Parliament. Does that all make sense? All right. Then go on to Chapter 5 of the New Lawyer. Before we start on that, I just want to make a comment, and that is about managing expectations of yourself and others. What you may find fairly quickly is that if you announce that you're studying law, people will start by saying things like, well, as you know, the law says this or the law says that. You won't necessarily know the law. And I want you to have a clear idea that you'll never know all of the law. None of us ever do. And a lot of us not me, but so people at the highest levels, judges, etc., they may only have a narrow focus, even though they're making very detailed decisions. They may say, look, I know all about criminal law, but I really don't know much about family law, or, those sorts of things. So even though you might be making very high-level decisions, doesn't necessarily mean you know other areas of the law. So as you progress through your legal studies and your legal career, if you go that way, just don't have an expectation that you'll know the law. What we're trying to teach you here are the general principles. You get a feel for the way it works, but importantly then, you know where to look to research for individual things. Legal Insurers says, stay in your own sandpit. That's a good phrase. I like that one. Now, there is a distinction between primary and secondary sources of law. Yep. Sandra said, in court regularly, I see lawyers refer to text often. Magistrates, judges refer to text, adjourn, stand out, or check legislation. Absolutely. So I was in court today and we had a situation. I've got to do some homework tonight. Just make sure of a certain thing. It happens all the time. But what we do is we sort of identify that may not be right. We better check it. It happens a lot. All right, so what do I mean by primary and secondary sources of law? Can anyone give me an example of a primary source of law? Legislation, act, statute. Yep. Terms that are essentially interchangeable. Tanya says, I'll give you two, an act and case law. I agree. So when we talk about primary sources of law, I'm really referring to statutes and case law. Another term for case law, common law in that broader sense. They're the primary sources of our law. Can anyone give me an example of a secondary source of law? Precedent, not quite much. Precedent is really part of our common law. Regulation, not so much. That's more part of our, if you like, legislation, but I know I'm using that in a very broad sense. Timothy says Australian standards. Yeah, although that I'd still put that in the primary category. I know these are very broad categories. Law reports, still put that in primary. Trade practice, that's interesting. Yeah, that's probably secondary. I'll accept that one, Maddie. Law journal, says Timothy. Yes, definitely a good example of a secondary source of law journals. Treaties, yeah, that's a bit of both. All right, so again, there's no specific definition on this, but just so you're aware, you may need to refer to, or you may read about primary sources or secondary sources of law. Primary sources, think legislation or that which is created as a result of delegation of legislative power on the one hand, and case law as primary, and pretty much everything else is secondary. So secondary includes textbooks, journal articles, information websites. They're examples of secondary sources of law. So as we proceed, I'll be referring you to both primary and secondary sources. Starting point generally always legislation. It seems to be legislation. Now that might be counterintuitive because we've given you a textbook and we've said read your text, and I know from school and from other areas, when people want an answer, they might go and look at a textbook first. But I'm going to ask you as you study law and practice law that you change that thinking. Other lecturers may have a different view on this, but my view is always look at the legislation first. Then work out what you think it is. Then you can go to the textbooks and the secondary sources to guide you through it if you're uncertain, or to assist you in confirming what you've determined for yourself. So I think the secondary sources should be considered after you've considered the primary sources. I hope that makes sense. Now, when you look at legislation, you need to consider the whole of the legislation before you immediately jump to a section and consider that section in isolation. The current approach is the purposive approach, where in interpreting sections, you need to think about the purpose or the object, and a good way to do that is to look at the early part of the legislation, typically, where it will have often a purpose or object clause. It'll actually tell you this is the purpose of this act. Sometimes there might be interpretation provisions in an act. So if you see a word in legislation, it may have a definition somewhere in the act, and the definitions are usually in their own section, or they might be in a schedule. Beyond that, you can work out the you can assist interpreting the legislation by looking at extrinsic materials such as a second reading speech or an explanatory note or explanatory memorandum. Is this all becoming a bit hard? How do you read legislation? Yes. Any questions there? No, sorry, I wasn't sure if someone had a question. All right, so legislation can be difficult to understand and read, but I'm going to recommend you find this. It's called How to Read Legislation, a Beginner's Guide by the Parliamentary Council's Office of Western Australia. How to Read Legislation, a Beginner's Guide, Parliamentary Council's Office, WA. And here's an extract from the opening statement of that guide. I really like it. It says, a lady called Lisa asked if there was a book with the basics about how to read and understand legislation. Something like a How to Read Legislation for Dummies. This publication, the one I've just referred you to, tries to be a beginner's guide for readers of WA legislation. It tries to explain things simply and shortly. I really like the way in which that is written. Keep that in mind. That's a really good way of writing, but it's a very good website for explaining things. I know that I'm referring you to much more than the textbook. And when you enrolled for this unit, you got your textbook, you looked at it and thought, maybe I can cope with that. That doesn't look like too much reading. And now we're into week 3 and the penny's starting to drop, isn't it? And the penny is dropping that the reading that you need to do in law is far more than the textbook. And in some ways, the textbook comes last. It's an excellent text. You've got to read it all. I want you to take it all in, but there are other places where you need to look and gain information. As you come across something and you think, that's good, I like that, build it into your toolkit. So always have, by now, you should be well and truly into your first assignment, probably almost finished it, and you should also be looking at the second assessment and create a skeleton for yourself so that you can start to fill in material as you progress, so that by the time you actually come to write the second assessment, as it were, you've got a skeleton and you've already populated a lot of material just from things that you thought, oh, that looks pretty good, that looks pretty cool on the way through. Any questions about what I've just said? Let's digress for a moment and talk about the first assessment. Now, if you think you're going to fall in one of two categories with this first assessment piece, many of you will fall into the category of saying, really, I get 20% for that? There's nothing to it. And there really isn't. I want you to build something that looks nice. You don't have to go to 1,500 words. You can have many less words than that. But what I'm asking you to do with the portfolio is build a platform that you can use throughout your studies and your career. So it's a matter of getting to know the technology so that you can build on it. Others will say, this is incredibly difficult and incredibly stressful. I don't know how to do these things, which is a great opportunity now to learn. And what I've found every time I've taken this unit is that there are some people who are really good at this and they're always willing to share their information and help. So if you're really good at the first assessment, the portfolio, like in terms of the technology, etc., would you make that known? I'm not asking you to be boastful or anything, but just offer your services so that if somebody's really struggling, maybe you can contact each other and work collaboratively through it. Does that make sense? Does anyone want to volunteer to say, yeah, look, I'm onto this. I find it pretty easy. So, and you can unmute the microphone or just now, who would say that they're pretty good at the portfolio and the technology behind the portfolio? Here's your chance to volunteer. The videos from Scott Beattie are good. Rachel says, no, not me. Gareth's worked out to do hyperlinks. Yes, good. It's all good technology. I'm not getting any volunteers to say, I'm the person. Peter, good on you, Peter. Peter Root says, I can work most of it. Abby says, are we meant to include anything, including professional communications and ethos in the online portfolio? Yeah, you are. So the idea is that if you create a Word version, you effectively replicate that for the online portfolio. Now, you can leave it in this form until I've assessed it. Then if you don't like it for future reference, you can just remove it, because then it really becomes yours. But for the purpose of the assessment, include those things as part of the online portfolio. I hope that makes sense. Have you looked at the material by Nicholas McIntosh, who was a colleague of yours, who's a few years ahead of you? He prepared some material that's excellent as well. All good? All right. So if you feel that you can assist others in that space, please let us know through the Q&A section. If you're struggling, likewise, please let people know and ask for someone to assist. Now, the second assessment I mentioned is not that far away. It's the 17th of January, and it's a toolkit. So you should start to at least have a skeleton in place and start to map out with some headings how you're going to go about this toolkit process. Then as you come across something that's interesting, useful, something you say, yes, that makes sense to me, so now I know where to go. You might put in a link to a website. It's meant to be a repository of information and external sources, information and external resources that works for you. Okay. Any questions then about the first or the second assessment? All good? Well, I'll just wrap up for fairly soon. So in terms of the, so the question is that on a Word document, the second assessment? Yes, the second assessment is a Word doc. But within that Word document, you might include links to resources. You might include flowcharts, checklists, whatever else you think is useful to map out your process. Now, the making of legislation, you'll need to know all about bills, the fact that bills progress through first reading, second reading, debate, committees, third reading, ultimately become law upon royal assent. You'll need to look at the Acts Interpretation Act, both Queensland and federal. Queensland, have a look at section 15, capital A. 15A is how we describe it, of the Acts Interpretation Act, Queensland. It's 1954. At a Commonwealth level, look at section 3A, subsection 2, 3A2 of the Acts Interpretation Act, Commonwealth, which is 1901. And you'll see there the way in which the federal and the state parliaments, respectively, deal with the issue of determining when legislation comes into existence by reference to the date of assent. I won't give you the answer, but just have a look at that, because that's the sort of thing you'd probably want to include in your toolkit. All good? Okay. Finally, for tonight, there's some excellent info sheets on the Parliament of Australia website, and I'm going to leave it at this and ask if you could find 2 info sheets. Commonwealth Parliament, number 7, Making Laws, which is called Making Laws, and the second is info sheet 20, which is the Australian System of Government. So this is Parliament of Australia info sheets, Commonwealth. See if you can find that. And I think that will help you in terms of putting all these things together. Okay, well, you've been very patient. Very good. Any questions before I wrap up for this evening? All fine? Can you confirm which info sheets? Yes, the number 7, Making Laws, and number 20, the Australian System of Government. Any questions? You can feel free to share questions in the Q&A section on Moodle. Otherwise, we will see you next week. Keep up the good work, keep up the enthusiasm. Sorry we covered a lot tonight, but we've got a lot to go through. We'll see you all next week. Bye then.